Welcome to our speakers, and we've had a massive response with over 320 people signing up to this event. So I've just given a moment for people to join us from all over the world. I can see in the chat. So on behalf of Freedom United and the Sunita Jain Anti-Trafficking Initiative at Loyola Law School, my name is Joanna Hewitt-James. I'm the Executive Director of Freedom United, the world's largest community against all forms of modern slavery globally. And we raise awareness and turn that awareness into action to build power for change in a world resilient to modern slavery. We're really pleased today to be partnering with the Sunita Jain Anti-Trafficking Initiative in Sacramento, who are driving forward the passage of the California Assembly Bill 1362 to protect all migrant workers in California. And together, we're bringing you today's conversation on safeguarding migrant workers' rights in California. And it couldn't be more urgent as the federal government is escalating its crackdown on immigrant communities in Los Angeles. And we witness a violent display of how deeply the system is devaluing migrant labor and treating people as disposable whilst profiting from their work. Now, in stark contrast, this bill, which is Assembly Bill 1362, offers a chance for California to stand for rights, not repression. It can be a turning point in how California protects the rights of people who are arriving from abroad on temporary work visas, many of whom face serious risk of coercion and abuse under the current guest worker programs. We are delighted today to have to listen to this conversation between two leading voices in the anti-trafficking movement, both of whom are former US ambassadors at large to monitor and combat trafficking in persons. Ambassador John Cotton Richmond, now Chief Impact Officer at Atlas Free and leader of the Libertas Council, and Ambassador Luis C.deBaca, co-author of the Trafficking Victims Protection Act, and now a professor from practice at the University of Michigan Law School. Both bring decades of experience shaping US and international anti-trafficking efforts, experience that's crucial as we consider how to build state policies that truly uphold human dignity. So we're honored to host this conversation. A big thank you to Professor Stephanie Richard at the Sunita Jain Anti-Trafficking Initiative and my colleague Krista Bismuth at Freedom United. If you have questions for the ambassadors through the event, please submit them throughout the session. There's a Q&A function you'll see at the bottom of your screen. That's the best place, or otherwise just in the general chat. We're also live tweeting at Freedom United HQ. And you can support this bill by signing our petition. We'll put the link in the chat. So let's get started. Over to you, Lou.
Thank you, Joanna, and thank you first of all, to Loyola Law School and to Freedom United for hosting us. John and I have had a lot of conversations, whether over coffee or a beer or on airplanes or in waiting rooms or things like that. But it's great to actually do this in a way that I think hopefully will front some of these issues that, as you say, Joanna, are, I think, really coming to a head as some of the international consensus and some of the domestic consensus around migrant labor is under some pressure here in the United States and in countries around the world. I think one of the things that's really important for us to tee off is that John and I are here as representatives, not just of ourselves, but of the 6 former trafficking ambassadors for the United States that are still alive. One of our predecessors has passed, but we're talking about people who go back to the creation of the office in the early years of the Bush administration, through President Obama, through President Trump, through President Biden, and all of the living ambassadors from the trafficking office have come together to strongly support this bill, AB 1362, that Assemblyman Ash Carla from San Jose has brought forward. And one of the reasons why you see us reaching across the aisle and working in concert in all of these things, as far as a bipartisan or across political approach on our parts, I think, is because it is something that we think transcends politics. It's something that every major religion is horrified by, every major culture is horrified by, and yet at the same time, it, like so many other social ills, survives. So we have to be vigilant, and we have to do it together. And I've been lucky enough to be able to work with John Richmond over the last, don't even want to say at this point, this last number of years, as we've come to it with our backgrounds, our diverse ways of thinking and working in the world to go together against those who would exploit. I want to tee up John really quickly, to say why it is so important that former U.S. trafficking ambassadors would weigh in on something like this. At the end of the day, what we're doing is we're saying that the foreign labor recruitment is not always human trafficking, but it can create human trafficking situations. It can create those imbalances of power that we have dedicated our lives to standing up to. Some of you, though, might not be familiar with the role of a trafficking ambassador. The United States is the first country that had it. There are typically ambassadors to deal with war crimes, ambassadors to deal with global women's issues, ambassadors to deal with human trafficking. So it's what we'd call a functional ambassador, not an ambassador to a country that's giving receptions and meeting with people from all over the different issues that the U.S. faces with that country, but an ambassador that actually coordinates U.S. diplomacy and U.S. foreign policy on a particular issue. And John and I, as I said, were blessed enough to fill that role at different times. Ambassador Richmond, could you maybe explain to us what a trafficking ambassador is and what we did in that capacity? And you're still on mute, John.
I really like the way you started that explanation of distinguishing between ambassadors and residents. So an ambassador to a specific country to represent any issues that might come up bilaterally between the United States and that country, and then an ambassador at large. An ambassador who's not an ambassador to one country, but to everywhere, but not on any issue, just on one specific issue. And I'm really grateful that Congress elevated the issue of human trafficking to having an ambassador at large level position in 2000. It's a unique position in our government. That's the highest ranking position that's dedicated to combating human trafficking. Unfortunately, we've always had individuals in that position who have understood the space, understood the issues around trafficking, understood how we developed and why we shifted in 2000 to a new focus about how to meet traffickers the way they're actually operating today. Their use of nonviolent coercion, the impact of trauma on victims, the importance of elevating survivor voices and centering them in our discussions about trafficking. The ambassador at large on trafficking leads U.S. foreign policy on trafficking, so engagement with other countries about how they're doing to implement their domestic laws and making sure those are aligned with both the UN protocol on human trafficking as well as the U.S. Trafficking Victims Protection Act. And we come at that humbly, having a difficult history with the issue of human trafficking in the United States, but we also come at it boldly because we want to lead towards human dignity and freedom for all people. One of the unique things about the Trafficking in Persons Office is that it not only engages in diplomacy in the traditional sense, but there's often historically been foreign assistance that we've been able to direct to help civil society organizations and governments around the world do better at delivering on their promises. Making sure that we hold governments accountable and that we're transparent in that through the Trafficking in Persons report, both giving a narrative on each country's ability to respond both around prosecution, that is accountability for the women and men who commit this crime, the traffickers, but also for protection. How are we thinking about victim identification and trauma-informed services to survivors that are narrowly tailored to how that survivor actually needs help? So not shoehorning survivors into prescriptive grant-driven programs, but thinking about what does this survivor need, knowing that every survivor is unique and different and is going to have different needs. As well as, in addition to prosecution and protection, there's also this third P of prevention, thinking about how do we engage in conversations and activities that don't just do general poverty alleviation, but actually do prevention work that impacts how traffickers actually operate. And I think there's some really impressive prevention activities out there, which brings us to this conversation today. When we think about a prevention effort, as Lou said, not all recruiters or violations of recruitment law are going to lead to a forced labor or sex trafficking situation. But we do know that when people are vulnerable, they're more likely to be victims of crime, and that includes the crime of human trafficking. And so whether it's an individual criminal, a cartel, or it's a corporation, if they're engaging in activity that violates the law around forced labor, we want to make sure that we're leaning in and holding them accountable. The last part I'd just say about the Trafficking Ambassador, Lou, is I'd love to highlight the interagency coordinating role that the TIP Ambassador has played over the years, which is a really unique role for a position out of the State Department, in that it's a domestically centered piece of how do we help communicate between the Departments of Homeland Security, Health and Human Services, Justice, Education, Transportation, all the different departments that have some role to play, and leading a conversation with them and a coordination effort, all the way up to a presidential cabinet meeting each year that's centered around trafficking. It's an incredible job, and everyone comes to it from a different perspective and informed by their life's experience. Lou, you had this job long before I did, but I remember sitting with you in your office when our offices were almost right next to each other, and learning so much about your experiences, and I benefited from those. Would you be open to sharing a little bit about how you came to the position?
Yeah, I think that one of the things that is interesting is that, and anybody that's seen me, do something with kind of my law professor hat on, knows that I very much think that this is a movement that started not in 2000 with the Trafficking Victims Protection Act and the Palermo Protocol, but this is a movement that started in the late 1700s with the beginning of the end of the transatlantic chattel slave trade and legal and economic setup. And I think that one of the things that we see in the United States is that starting in the 1930s, there was a small unit in the Justice Department that was focused on doing civil rights work, whether that's police brutality, whether that's hate crimes, whether that is what we call slavery today. Back then they called it peonage because it was very much thought of as being part of a debt bondage situation. But whether we call it peonage, whether we call it involuntary servitude and slavery, whether we call it human trafficking, all of which it's been called over the last 100 years, had this little office, almost 100 years, in the civil rights section and then in the civil rights division. And I was lucky enough to get in there after law school. And there's a little bit of a last man standing thing, is if you end up having the most slavery cases on your docket, then suddenly you become the coordinator, I guess. You're coordinating yourself. And I was able to take over from C.deBaca, who did a lot of very important work on these cases, as the involuntary servitude and slavery coordinator. Now that sounded a lot more like I was telling people where they should be deploying their enslaved people than it probably should have. And it gave me an opportunity to work on the policy. It gave me an opportunity to start knitting together those relationships across the government. But one of the things that we saw was that the people who were working on it were the people who were doing the policy, and you could have the entire intergovernmental meeting in the back of a Border Patrol agent's van, because we had a really good plainclothes Border Patrol agent who was dedicated to going out and finding people who were being hurt by their bosses. And Mike Barone really taught me how you could use the power of government to do that. And that's been in my mind the last few days, as we've seen, kind of the greater angels of our nature on immigration enforcement, things like what Mike Barone taught me, as far as using those tools to help people, are not at the front of the headlines at this point. But what I was able to do with that is, to solve some problems that we were seeing in the cases. There was anti-immigrant legislation passed in the late 1990s that required us to go out and put together some exemptions, ways to put people into immigration status, ways to get them jobs, ways to have them be able to access social benefits. And I was able to grow that unit so it wasn't just me doing the cases, and we started getting good people coming in with relevant backgrounds, such as John Richmond coming in from International Justice Mission, having done this work in India and other parts of the world. And I think that what we saw was kind of that as the United States was doing this, that our partners in countries around the world were also rising to the occasion. And so now I think it's part of a global community of anti-trafficking actors. And one of the most exciting things is and I was able to do this when I was ambassador, as far as to found and bring forward the Survivor Advisory Council that I then handed off to my successors to implement. But that idea now that there are victims of these cases who are out, that have become survivors, that have become advocates, that have become trained either in better ways to share their lived experience or ways to harness their lived experiences in order to make real positive policy recommendations. And so I think that what we're seeing is that this exciting growth of a community worldwide is now being fueled in a very positive way by the exact people who need to be at the table, which is the survivors themselves. John, I kind of, noted a little bit about what you were doing before we lured you into the Civil Rights Division, but can you maybe talk about your journey as well? How did you go from young law school graduate thinking about making a difference in the world to now John Ambassador Cotton Richmond?
Yeah, when I graduated from law school, the TVPA didn't exist. And I went to work for a law firm. I practiced law for 4 years doing commercial litigation. I learned a ton. And an opportunity arose to join a small NGO at the time that was just really starting out, called International Justice Mission, that Lou mentioned. And they offered me an opportunity to do something I'd always wanted to do, which is live somewhere other than the United States and explore what life would be like, this grand adventure. And so my wife and I and our 15-month-old daughter moved to India and lived there for a little over 3 years. And my role there was figuring out, one, Indian law on forced labor in human trafficking, building a team, building a replicable model of intervention, thinking about how do we actually identify victims of trafficking, and take Indian domestic law and help the actors there, whether it's administrative or judicial, implement that. And how do we resource them and help them become better and better at doing their jobs to see more and more people find freedom? In that role, I got to meet a lot of victims of trafficking and listen to their stories and learn from them about how it starts, what it's like, what the difficulties are even after someone is separated from their trafficker. But I also got to meet a lot of traffickers and listen to them. And I learned a great deal as they talked to me about how they viewed individuals as if they didn't have inherent value. They didn't have dignity, that you could treat someone as a commodity to just profit off of illegally. It was a great place to cut my teeth, mostly doing rice mill, brick kiln, rock quarry type cases, but also some sex trafficking cases during that season. And then I returned to the United States and joined the Civil Rights Division's criminal section, which has often been called the crown jewel of the Department of Justice. And I certainly believe that to be true. I loved my 10 years at the criminal section, got to do police misconduct, hate crimes, but most of my time ended up trailing into human trafficking cases. So both sex trafficking and forced labor cases all around the United States, and got to try those cases with the support of incredible FBI agents, incredible ICE agents that care deeply about their jobs, that care deeply about victims, as they went out and tried to make sure that we could hold people accountable and make sure that survivors got services. When I left the Department of Justice, I continued to engage kind of internationally on trafficking until I was given the opportunity to come to the State Department and begin to work on trafficking from a foreign policy position. And I, again, learned a great deal about types of trafficking like child soldiers, and state-sanctioned forced labor that I had not been focused on before. I felt like really grew the breadth of my understanding about trafficking. And now I get to continue to work with various NGOs on trafficking, but still draw a great deal of insight from my experience at the TIP office, and I'm grateful for my colleagues there and the hard work that they have done over the years, putting out an incredible TIP report, but also thinking with innovation and insight about the issues of the day, which really brings us to today, Lou. And so I guess what I'd love to do is hear what motivated you to get involved in this pursuit of a broader law to protect migrant workers in California, and specifically 1362.
Yeah, it's so interesting because I think that, one of the things that we saw when we were in the Civil Rights Division was that notion of kind of a important central federal government office that had expertise and was able to deploy it. And, frankly, that goes back to the late 1800s, because the reality is that a lot of Southern law enforcement, even Southern federal law enforcement, wasn't going to do these cases protecting the Black or immigrant communities. So you had to send people out from quote unquote main justice to do those cases. And so I think that one of the things that I've realized is that I had a bias towards, let's just have one great big, legislative scheme at the federal level and we'll be fine. Which works really well if you're England, or if you're Italy, or if you're a non-federal country. But in the United States, the action really is out at the states. And so I think that one of the things we've seen is that California in the legislative side has been real leaders, whether it's on stepping up about supply chain transparency issues, whether it's the precursor bill to this particular legislation, SB 477 from about 10 years ago, that Darrell Steinberg was able to get through. But often we see it getting bogged down. We see the legislators do the work and then they kind of move on to something else, and especially in California where you have term limits. So this is one of the things I think so important about what we see with 1362, is that it's taking a look and it's saying, why wasn't Darrell Steinberg's bill working? How do we put pressure on the Cal Department of Justice and other parts of the California government, but also how do we give people the tools to bring cases on their own, whether it's folks from government or whether it's victims. And so 1362 is really, kind of filling those gaps. And what are those gaps? Well, one of the things that is interesting is that there's about, 350, 400,000 temporary workers that come to California every year. And those are ranging from technology, agriculture, kids down at the beach, who are scooping ice cream, nurses, teachers. I mean, there's so many different things that end up getting filled out by folks coming in on temporary employment-based visas. But notice I said employment-based visas. It basically says you can be in the United States because you're here to work. And if you somehow then counterintuitively aren't working, if your boss says, I'll fire you if you don't submit to my sexual advances, or you give me your passport and you don't leave, or else I'll turn you in. All of those things are kind of endemic to these types of visas, these work-based visa programs. And I certainly saw this, and I think that you did as well with your work in Saudi Arabia and in the GCC countries. When you have work-based visa programs that don't have any protections built in, even an employer that maybe didn't start off to be a trafficker or didn't start off to be an enslaver can cross that line if you don't design the protections. And so that's one of the things that I think is so exciting about this. 1362 is going to look at the most harmful recruitment practices by, first of all, requiring everybody that's bringing in folks as labor recruiters, they have to register with the California Labor Commission. They have to post a bond. Hopefully we wouldn't have somebody come and work on the electricity in our house without knowing that they're licensed and bonded. Those are there for safety. This does the same thing. It says that the safety of the migrant worker, the people who are coming in and really running the California economy, the California miracle. It's one of the 5th or 6th largest economies in the world. And that's very much because of the contributions of people from other countries. It also prohibits recruiters from charging workers recruitment fees. One of the things we've seen, and I mentioned that the early years of this fight, for a long time, they called this peonage, debt bondage. I certainly did cases, and I know that John and our other colleagues in the Justice Department did cases where a good portion of the coercion came from the fact that somebody had a great big debt. And sometimes those debts are $25,000, $30,000 if they were to try to run off or leave or not do what the bosses say. That's your parents' house. It's the very thing that you immigrated so that you could work, so you could send money back so your little brother or sister could go to school, or paying for that operation. Suddenly, you're going to be in debt for the rest of your life. So I think that that's one of the things that we see is, this idea that there needs to be no recruitment fees and there needs to be transparency. So the bill also mandates that recruiters provide contracts in the worker's own language, and so that the workers really know what happens. Gosh, so many times we hear these stories, whether it's from survivors or from workers or in investigations that we're doing, where there's the contract, and then there's the contract that they get when they get on the plane and their wheels up, and it's too late. And then they get told, here's the real contract. Or there's the contract, and they're like, oh, it's in English or it's in Arabic. And they have no idea what they're signing, but they've already paid the labor recruiter. So this bill, I think, shines the light on that. And I think it's really important because what it does is it makes it so not just the worker, but the employer knows that they are not crossing the line. If I was staffing a high school or if I was staffing a hospital, I would want to know that I'm working with labor recruiters who are not doing those types of things to their people. So in my mind, I actually see this as a kind of a strong pro-business bill that encourages and rewards the good actors. John, I know that having served under a Republican administration, that some of the people who'd come visit you in the office probably were a little more pro-business than some of the activists that would come and visit me, although I think we all tried to do work with the business community as well as the advocacy community. Why is it that, when you look at this, or when in talking with the other folks who served under Republicans in this role, why is it that you guys, I think, are with us on this idea of this being good for business?
Yeah, one of the things that has always encouraged me is that combating human trafficking has been a bipartisan issue. We've had champions over the years on both sides of our political aisle who care deeply about it. And I think it's because it comes from this fundamental idea that everyone has inherent value, that everybody matters. And if we think everybody matters, we ought to be treating them with dignity. And so if you come from a faith community, it might be a foundation that Imago Dei, this idea that everyone is created in the image of God. And if you're not from a faith community, maybe you just look at the Universal Declaration of Human Rights. It says everyone has inherent value, that rights don't spring from government, they precede government, and governments should not be interfering with those rights. And so there's a lot of room for people who might disagree about tax policy or might have different views about other issues to come together and say that we want to make sure that traffickers are not exploiting people in commercial sex, they're not exploiting people in types of legal labor either. Very real way, I think that you can believe in strong borders and law and order and ethical recruitment. You can actually believe that you want people to be cared for. And the burdens that this bill imposes on businesses are fairly modest. Having a labor contract, if there's going to be a contract, not just employment at will, if there's going to be a labor contract, it ought to be written in a language in which the worker can read and appreciate and understand what are the terms that they're agreeing to. Having that translated into that language feels like a very reasonable piece. Lou, you mentioned the bond, also reasonable registering as a recruiter, making sure that employers are not withholding documents like passports or ID cards or other types of documents from workers sort of as safekeeping. Even if their intent is benign, I think the consequences can be quite harmful. And we want to make sure that people retain their identity documents. Foundational to a flourishing economy is that workers get to alienate their own labor, they get to decide when and where they work and when they want to quit, and if they want to compete in the marketplace for a job somewhere else. And that causes companies to have to compete in the marketplace for workers. Not all workers are equally talented, and they might want to find talent density as they try to grow their workforce to accomplish their goal of providing a fantastic good or service in the marketplace. And we know that forced labor infringes on free markets. Forced labor is anti-competitive, it's anti-capitalistic. We want to stop that so that we can have human flourishing. We actually want people to be able to control when and where they work, who touches their bodies, when they decide to wake up. People may make good decisions or bad decisions with their time, but they ought to be free to make their choices. And I think that one of the reasons that there's bipartisan support for this is that it's good for business to have a healthy workforce, a workforce that's free. It's good for business to make sure that people aren't only working because you have their passport, or only working because they didn't understand what the work was going to be to begin with. And I think that is good for business. Businesses that are interfering with that, businesses that are operating unethically, are really trying to get an unfair advantage over businesses that are. And that doesn't feel right. That doesn't feel like the way that we want to move forward. Lou, we're talking about things in the abstract. We're talking about things kind of philosophically. Maybe you could walk us through sort of a case example that illustrates why the provisions of 1362 in California are meaningful and important.
I mean, I think that there's, several cases. And in fact, there's a case that I want to mention that's here in Michigan in the blueberry fields here in a few minutes. But actually, I want to reach back to one of the first cases that I did back in the 1990s, because I think that it's a case that had this happened in California, and if this bill had been in place, these women would not have gone through what they did. So it was women who were recruited from a part of China where the ethnic Korean community is very mistreated, and because of accidents of politics and history, they are on the China side of the line, and they're mistreated by Koreans and they're mistreated by Chinese. They had an opportunity. They were recruited to come to the United States and to work as waitresses, and the recruiter was somebody who they trusted because she came back and said, I did this and I'm going to recruit you. And brought over, a couple of dozen of these women. The part of the United States that they went to was an island that is 11 and a half hours west of Hawaii called Saipan, just south of the Japanese mainland. And it is part of the United States. And as a result, there were a whole bunch of exploitative garment factories there, where people from China had been brought in and were being held in coercive conditions. But these girls were put into karaoke bars and forced to work as bar girls and in prostitution for the Korean and Chinese businessmen who would come to the island. They thought that they had agreed to this because they said, well, we agreed that we were supposed to be in a bar, and I guess this is what bars in America are like. Their passports had been taken, there were threats made, a whole lot of abuse going on, even beyond the sex trafficking and the rapes that the women were going through. One of the things that I think is interesting about this is that, now can people hear me? I want to do a check. Okay, sorry about that. There's some internet things going on. So what happens, I think, is that, you get attention paid to the garment factories, and the Department of Labor goes out and runs an ad that says, you have a right to have your passport with you. They can't take your passport away. And that's on local television. It's in Chinese language. That night, a dozen women went through the window of that particular brothel and escaped, because they had that one piece of information that said, in America, you can have your passport. They can't keep you at your job without it. And so to me, interestingly enough, I think about this. If those women had traveled to the United States with a registered foreign labor recruiter who had a bond, not just some woman from their village who'd been sent back to get more victims, frankly, if they hadn't paid their recruiting fees as far as the cost of their travel, the cost of their flight, etc. They thought that it was going to take 5 years to pay off their debt, and then after that, they'd be able to have money for their families. And if they had had an actual contract that was in their own language that said what their rights were in the United States, they would never have been so vulnerable as to be in forced prostitution. And so I think that's one of the things that if I could pick up 1362, take it back in time and take it to Saipan, I feel like what I would have done is I would have found these folks as survivor activists who were helping other people. I would not have had to go in with the FBI and try to help rescue them in the way that we had to. And so I think it really does come, John, to, as you had said, this is the P of prevention. We can stop these cases from ever getting to that point. Same thing with this case that I mentioned in Michigan. You've got Guatemalan migrant workers who were promised stable jobs, and instead you have these misleading contracts, hefty fees, saying that you're going to get X amount. And especially, a lot of times people just can't pick enough of that particular, whether it's blueberries or tomatoes, they can't pick enough in a given day to pay off their trip, to pay off their housing, all of these hidden fees that would go away if 1362 comes into play. But John, I'd mentioned some of the other things out there. This isn't just agriculture. This isn't just sex work or garment or things like that. It's also in parts of the economy that we think of as being, legitimate parts of the economy, right? I'd mentioned teachers, but also there's nurses out there. There's a nursing case that we had talked about as we were preparing for this. Can you tell us a little bit about that nursing case?
Yeah, I think it's a really good point, Lou, that I think so often people think human trafficking is only happening in parts of commerce that have been criminalized, like prostitution or like someone running scams on other people or things of that nature. We're certainly seeing a lot of scam centers right now in the news in Myanmar. But there are certainly teachers and nurses. We just saw an announcement from the government, the state of New York, trying to protect nurses that have been brought in the United States from outside by a company. They were forced to sign agreements that included some pretty hefty penalties if they wanted to leave employment before the end of their term, liquidated penalties of $20,000 and many other fines that might come in. I think we've gotten a judgment now, or at least a civil agreement for that healthcare provider to provide over $660,000 to 71 nurses that had been taken advantage of. And the Attorney General of New York's theory was it was a violation of the Trafficking Victims Protection Act, of this idea that there was a scheme, plan, and pattern to cause someone to feel like they had to continue working even if they didn't want to. What's worth noting is not only that it's nursing, because I think we want to understand that human trafficking can happen in any possible industry. It's not driven by the industry, it's driven by the intent of the trafficker. And so here, a healthcare company has paid out a significant penalty, but I'm so encouraged that the way Congress drafted the Trafficking Victims Protection Act was to include a civil remedy, to include the ability, even if you can't prove this case beyond a reasonable doubt in a criminal court, there was a way to go after someone civilly and just have to prove by a preponderance of the evidence. And so fortunately, we have an opportunity for victims individually to sue people they believe have trafficked them and might be culpable, but also for attorney generals to bring suit on behalf of a class of victims. And that's a powerful tool to have that private right of action to make sure that we're holding traffickers accountable. So I was really encouraged to see that. Hopefully, we'll see more and more fair employment practices if more nurses are recruited and come into the United States to provide important care for people around the world who are sick and need services. Most of the people in a hospital are not thinking about, where did my nurse come from? How did they get here? They're just trying to get the care they need, and the nurses are providing important medical care. So someone has to be looking out for that situation of exploitation that might be out there. So there's lots of different cases that might benefit from that. But Lou, I know that you've got some other experiences. I also know there's some questions probably pending from the audience. So let me toss it back to you.
Yeah, John, I think that one of the things to think about, with the nurses especially, you've got very highly trained people who are doing very sophisticated things in their daily life and their daily job. And we often think of the trafficking victim as being, oh, they're vulnerable. Well, they're vulnerable, but they also might be in, in hour 12 of a 12-hour operation, where that they studied for years to be able to have that job. They're vulnerable to the trafficker, but these are very highly skilled people. And one of the things that we've seen with that is these cases out west in the dairy industry. And the U.S. dairy industry is under a lot of stress because it's a really tough job, and a lot of Americans don't want to do the work. And I think it's only going to get more under stress with crackdowns on immigration. And so what's happening is that you've had people advertise for veterinarians and animal scientists from Mexico and other parts of Latin America. And through these visa programs, especially under the North American Free Trade Agreement with Mexico. And so you get people who are coming to the United States very proud that they are going to be able to practice their medical specialty in the United States as a veterinarian. And instead, they end up getting put in records as milker, outside help, calves, etc. And it is very clear, and the Ninth Circuit Court of Appeals reinstated the lawsuit that the workers have brought with the help of the United Farm Workers lawyers to basically say, no, if you're going to do that kind of a bait and switch, it's something that you're going to be responsible for. You can't go and get a highly trained veterinarian, bring them up here, and just because you wanted somebody who would milk the cows and feed them. For me, having grown up on a ranch, I think that one has even more resonance. It's like, the veterinarian for us was a big deal when the vet came to the thing, and everybody I know that's gone to vet school is necessarily proud of it. But I think it to me, it just shows again that, these bait and switches only happen if you don't have a situation where transparency is forced on the employer. 1362, if that were to apply now, and if it applied up in Idaho, those farmers would not have been able to get away with that in the first place. Now everybody's trying to come back with something to make up for it and something to make the victims whole. It never would have necessarily happening. So I think that's one of the things that we have to really look at. There's some other things that are going on. We're all carefully looking at the Supreme Court this last week, agreeing to take on an appeal by GEO, which is a organization that runs detention centers involving immigrant detainees. And in those situations, you've got people who are doing janitorial services, who are the detainees themselves. It'll be really interesting now that that's going to go to the Supreme Court, even just what the arguments are. The Court of Appeals basically said, yeah, you can bring a forced labor lawsuit to that. Now, that's not something that would be a labor recruitment case the way that we're talking about now. And it's not something that 1362 would really have an impact on. But anytime a case goes to the Supreme Court, everybody that's working in that area has to be very aware, because there might be some knock-on things that end up happening. And I know that that's something that we have certainly raised with other countries as well, is that state-sponsored forced labor is something that has to be really looked at. The United States tries to balance the kind of need and desire of people who are in prison or detention facilities to actually do something other than be in their cell all day, against if it is so abusive or so profit margin oriented that it crosses that line. But that'll be an interesting case to look at going forward. So I figured, even if it's not really the purpose of our discussion today, once the Supreme Court did, the technical term is granted certiorari. So it announced that it will take that case. So over the next year, we'll probably be talking more about it. But I think that we have some questions, and we wanted to open up. We've got about 15 minutes or so for questions. Joanne, you were looking at some of the questions that were coming in. I don't know if you'd like to join us back on screen and ask the questions or tee them up for us.
Absolutely.
Thanks, Joanna.
Thank you very much. It's been fascinating following your discussion. Very, very interesting. And I think there's some good questions that have come in already, but before we kick off, I'd first just like to ask, what do you think are the key reasons some people might oppose a bill like AB 1362? So we've heard lots of good reasons why we should have it, but what would be the resistance for a bill which sounds like something that we should be doing anyway?
John, you want to take the first stab at that? I've got some thoughts as well.
Yeah, we might have some different thoughts. One is a lack of confidence in the regulatory machinery. I think a lot of businesses, even if they don't oppose the actual act that they would be required to do, have great suspicion of whether the government will effectively, fairly implement the regulations, if they will actually be able to handle that. The other question that's going to be in a lot of businesses' minds is if there is a right of action to sue, how much of their bandwidth is going to be absorbed by lawsuits that may not be meritorious. Obviously, they may want to comply with the law, but if for some reason they have complied with it, they're sued anyway, there is a penalty to defending yourself, even when you haven't done anything wrong. I think these objections can be overcome. I think we want to be careful not to impute bad motives because people might just be hesitant or actually have some valid concerns. We want to weigh those concerns against the reality and how we could look at other times where these sorts of regulations have been imposed, other regulatory schemes that have actually benefited business over time, even though they were initially resisted by business. How we have seen as the United States has increased some of its workplace safety, whether it was child labor or occupational health and safety or Americans with Disability Act, business has continued to flourish in spite of the restrictions and burdens that have been placed upon them to make sure people had access, to make sure that people were treated fairly. And I think in this case, the interventions are narrow enough and precise enough that those concerns can be overcome by practice. But I do think we want to look at businesses that might be hesitant, not as opposition, but as fellow travelers on a journey of trying to figure out how do we make sure that we have strong economic stability and flourishing prosperity so that everyone can do well.
I'd add to that as well that I think that, from a legal scholar perspective or, something like that, this idea of if you have a piece of legislation or regulation that applies to something, you don't go out and then get another one because that just makes it confusing, or you end up having cracks in the regulatory scheme. And I think that that's something that the first attempts to pass a bill like this, that frankly Governor Newsom and his people might have gotten wrong. I think that there was some of the opposition was kind of misguided lack of understanding about the difference between foreign labor recruiters and farm labor contractors. And I think that that's one of the things that hopefully this bill is going to be clearing up. The farm labor contractors, is a set of regulations that was put in place in the 60s, back when most of the people who were still working on the farms in the United States were not foreign workers. They were poor white folks from the South, they were poor black folks from just about everywhere, and they were a lot of people from the US-born Latino community, my uncle and others who went into the migrant stream. And those protections for farm labor contracting situations were put in place 50, 60 years ago with a very different world. And I think that this bill is trying to focus on the foreign labor recruitment. And I think that that is different and distinct enough that hopefully we can kind of solve that problem of the, a lot of what we do in law is we're saying one of these things is not like the other. And this is, I think, one of those things where accidental conflation might have gotten in the way of the bill last time that it was up for consideration. But I think, John, your point is, I think, tremendously well taken, that idea that, everybody out there is a potential partner. And Tori Curbelo actually just posted something in the chat that I wanted to raise to everybody's attention. A new agriculture trade association that would include recruiters, farm labor contractors, brands, growers, et cetera, focused on ethical recruitment. It's called aaalp.org. And I'm excited to learn more about that. And so hopefully will join me and everybody else in learning more about that. And Tori, thank you so much for raising your hand and mentioning this. Joanna, do we have, I think we've got time for at least a couple more questions, do we?
Yeah, we do. I think we kind of touched on a couple of them already, but of course, we know in 2022, it was Governor Newsom who vetoed the bill, so it did get all the way through the Assembly and the Senate in California. I think we've talked a bit about some of the resistance. I don't know if there's anything you want to add to that. If not, then I think we could move on to a question about how we hold employers accountable.
Yeah, let's move to the employer accountability question, I think.
Great. Okay. I think we just particularly knowing that a lot of unaccompanied minors unfortunately are being exploited. We're seeing increasing cases being brought, the Department of Labor investigating. So for what advice would you give to those working with unaccompanied minors in California to make sure that employers are being held to account?
One thing that comes to mind is take advantage of the Trafficking Victims Protection Act civil provisions. You can file a civil suit claiming forced labor if you've got the facts to support that. And it's stunning how few civil suits get filed. I think everyone involved in this case would love to see far more civil suits. Theoretically, we should have more civil suits than criminal cases because of the standard of proof that is required. And so bringing those cases into court and testing those theories, I think can be an incredibly helpful way to make sure that that not just is the victim's rights protected, but the accountability of the perpetrator is also considered. As you're going through that, I just highlight that we have a provision in the TVPA that says that you don't have to recruit, coerce, or groom someone in order to be guilty of human trafficking. If you're benefiting financially or otherwise from a trafficking venture, you're also liable. So even if you never recruited, groomed, or coerced anyone, you never physically forced them yourself, if you're benefiting financially from doing that, there is a liability track for them as well under the Trafficking Victims Protection Act.
I'd add to that as well, John, and this is probably not something that we front when we're saying, hey, businesses, you should support the law. But if there is a requirement that you have registered, that you're not charging fees, etc., that ends up starting off the trafficking case with a bit of a win in the pocket of either the private lawyer, the California AG, or if it's a county attorney, a prosecuting attorney office, or even a Fed, is that you can come in and basically say, okay, well, wait a second, where's your bond? Where's your registered foreign labor recruitment that you're required to have under 1362? And then at that point, you start pushing past that to, okay, where's the money that they were owed, and why did you threaten them, and everything else. But I think that one of the ways that one can hold the companies accountable, is having these kind of lower level things, and it also, frankly, gives you something that you could make an agreement with the company on. Maybe it's very clear that they weren't using a registered foreign labor recruiter, but it's murky as to whether or not they were actively holding them in servitude. It gives you an opportunity to then make a deal and basically say, okay, company, first thing we're going to do is you're going to agree with us going forward that you're always going to do that, and we're going to monitor you. And certainly we've seen in Florida with the work of the Coalition of Immokalee Workers and others, that farm labor contractors and growers themselves, who 20 years ago were very high on my target list, are now seen as innovative, good actors because they're working hand in glove with their workers. They're doing that in no small part because 20 years ago they decided that they were tired of getting investigated all the time. And so, I think that idea of, moving them towards partnership, sometimes you have to move them towards partnership with something that they might be a little afraid of as far as the risk or the exposure that their company might have.
Thanks. Luke, do you think we have a chance to ask
Yeah.
one more question? I think it's quite an interesting follow-on from the points you've both raised about using the legislative process and the mechanisms that are already available to us. And Joseph's asked, what about also using like a public health approach rather than just a law enforcement approach? Should other agencies be involved? I think he's quite interested in the role of law enforcement in preventing, but also in how we can reduce human trafficking through a non-legislative public health solution.
Yeah, this is one of the things that, in the child labor class that I teach, that's cross-disciplinary, was very, it was a real value add to have both social workers and public health folks in the room, as well as people from the business school, the policy school, the law school, et cetera. And part of it is trying to figure out what are the levers to get companies to sign on to a kind of a public health type of an approach. So I think that what we've seen is the tools of public health have been very useful in confronting these, especially through the Office to Combat Trafficking over in HHS, that unfortunately has become very much under fire in the last few months with the new leadership over there. So politically, I'm afraid that some of what we were seeing as far as kind of public health tools, thinking about kind of community-based interventions, thinking about kind of not just best interests of the child as from a legal standpoint, but best interests of the child and centering the child's experience in everything that we're trying to do, whether it's from victim services or whether it's child placements, et cetera, right now seems to be under fire. And I think that some of the things that we have to do is simply insist that the public health specialists at HHS get to do their jobs, because I am afraid that some of what they're being forced to do right now is under the guise of checkups and check-ins as to to child welfare check-ins, that they are sending ICE agents out to do the public welfare check-ins as opposed to sending health department people. And so it raises the question as to whether they're really interested in the welfare of that child and more about whether they're just trying to figure out a way to get through the door. John, I don't want to leave it on such a negative note, but I know that something that you did a lot of work on when you were an ambassador, as far as how do we make those connections with the public health folks?
Certainly, I think there's a huge overlap when victims go to healthcare providers while they're being trafficked. I think there's some studies out of Arizona that suggest it's an incredibly high percentage, over 80% of victims. And it's a victim identification opportunity. But I think the public health approach itself, when you think about how it's impacted seatbelts or needle exchanges or speed limits, things of that nature, make a lot of sense. We haven't seen a lot of examples where a public health approach to actually ending criminal activity have been successful. But I would note that, like, what we've been discussing right here is not a criminal justice approach at all. This is an administrative and regulatory approach. So this is certainly not a discussion about we're going to prosecute our way out of trafficking or arrest our way out of trafficking. This is far from a criminal justice focused intervention in terms of the passage of this bill. Although I would note that no single intervention will be successful. Prosecution is a necessary but not sufficient condition of relief. So are shelters and services and prevention and reforming foster care, and as well as this bill. So I think it's going to be a whole of government and a whole of culture and society as we try to elevate freedom and human dignity.
I think that's a super important point that I'm glad you made, John, about this response being regulatory and civil and not a criminal response. But I think actually that does bring us to an end of the questions. There was a question which you touched on, Lou, which I think is just about the importance of having trust in departments, because there was the questioner has said that Department of Labour might ignore reports of trafficking. So how do we ensure there's trust? And I think that is going to be a big question for the authorities going forward, how to maintain trust when actually we're seeing lots of examples and evidence where that trust has been breached. So I think you touched on that already. So I think that brings us to the end of our questions. Thank you very much. Perhaps I could close the meeting then, Lou,
Yes, please.
if that's good for you. I'd also like to say a big thank you to both our ambassadors who joined us in this conversation today. Very grateful to have both of your contributions and presence on this important topic. Also to all the participants who joined us from around the world. I saw that you from everywhere. And please join us in this fight against human trafficking and in labour recruitment. It really depends on these strong policy changes, and this bill is a really crucial step in making that happen.
And we can and please join us by signing the petition.
Yes,
Signing the
please.
petition. Can I say one thing? Because I just saw that somebody was on. I noticed that Paul Chang, who actually was part of that child labor class that we did, and has been doing this from Department of Labor all the way back to the El Monte case in the 1990s, had joined us for a while. And I just want to give a shout out because I think that Paul's work at DOL is just indicative of why should they trust us. They should trust us because this is a government that has people like Paul Chang working for it. And so I think that we don't know those people's names in the California system. We don't know those people's names in Argentina and Nepal and Spain. But there are people like Paul out there who are working in government and that they are dedicated. And if we can just find them and encourage their work.
Thank you, Paul.
That's very true. Thank you. Thank you again to both of you. Thank you as well to my colleagues at Freedom United, and also thank you very much to Loyola Law School, who are working really hard to get this legislation through to better protect workers everywhere in California.